disputes are inevitable. It is one of those things that are inevitable aspects of life. As individuals, we have seen property disputes, tenancy disputes. We inevitably have to enter into a contract. Not all of us go through each and every clause that in most instances leads to dispute. Existence of disputes themselves is not a problem. It is the lack of credible, accessible avenues to resolve disputes. Today, the biggest roadblock for India's growth is the state of its judiciary, that the process itself becomes a punishment. How long does something like that today take? 3 to 4 years. Even the simplest of cases take anywhere between 6 to 10 years to get resolved and see some level of finality. The question that all of us as ordinary citizens are faced with is this even worth my time? And most often the answer is no. We write it off. We swallow the bitter pill and move on with our lives. But there have been alternatives. You may have heard of arbitration, you may have heard of mediation. Mediation is a mechanism where you bring in a neutral facilitator. Everything has been designed, these have been offered as a brick and mortar solution. Dispute resolution with a digital first approach. Our average dispute resolution time for the last 82 days. It is mostly 2% of the claim value that you end up spending on our platform.
Without further ado, I now invite the speaker to share her insights on a modern approach to resolving disputes quickly and effectively.
We are going to be talking about something that I believe is relevant for all of us as individuals, as people who may be employees in different workspaces, or as people who may be running our own businesses. And this is something that I think is all pervasive, and that is disputes. Right? It is one of those things going back to some very tried and tested jokes regarding lawyers and doctors, right? You never want to fall sick. You never want to end up with a legal issue, but these are inevitable aspects of life. And what is important for all of us is to know what is the best remedy that is available out there, depending on the kind of issue, be it health or be it legal, that you're stuck with. So what I'm going to be talking about today broadly comes from my own experience and my position today as co-founder of an online dispute resolution institution. But I hope the way I have structured the conversation will be something that will resonate with you all. I don't want to use this platform as an advertisement for my own institution. I want to be able to truly share with you all how to deal with disputes and maybe explore various avenues that are available, and leave it to you all to see what again suits your situation and your dispute the best. Broadly, what I will be talking to you about is dispute resolution with a digital first approach. The umbrella term or the popular phrase that is used to capture this is online dispute resolution, or ODR. I will talk to you about the various variants that exist within ODR, but it will help if you're familiar with what online dispute resolution is and what digital first approach to dispute resolution might entail. As I was mentioning, right, disputes are inevitable. And what you see on the slide are perhaps some of the very prominent disputes that we as individuals or as owners of businesses may have experienced. As individuals, we have seen property disputes, tenancy disputes. We rent a house, we maybe purchase a house, and then we inevitably have to enter into a contract. Not all of us go through each and every clause of any contract that we sign up for. That, of course, is what in most instances leads to dispute. But then it is, as I have stated here, disputes are inevitable, and disputes are also a sign of a thriving life, a thriving business, and thereby a thriving economy. It might seem that in India, we are faced with conflicts differences and disputes at every turn of our lives. But in fact, if you look at the rankings across the world, India is one of the less litigious countries. More advanced a country is, more litigious the society becomes. What does that mean? You are having many more interactions with people around you, many more varieties of interactions with other businesses, and that is a sign of thriving economy, right? If your business is doing well, that means you're entering into lot many more contracts on a daily basis, and it is only realistic that that at least some percentage of those contracts will result in a dispute scenario. So thinking about or reframing disputes this way indicate to us that we should in fact be welcoming of disputes. But unfortunately, unlike what we have in advanced economies, we do not have satisfactory avenues to resolve disputes. So existence of disputes themselves is not a problem. It is the lack of credible, accessible avenues to resolve disputes is what is creating that stuckness in our lives and in our businesses and thereby the economy. But if you see everything that I've listed here, right, except for maybe marital and family matters, everything else is a sign of us living our life to the fullest. We as consumers keep buying goods, and it is only natural that some of those goods may be of lesser quality or maybe may not meet our standards at various levels, and that is fine as long as I can immediately thereafter go and get my grievance redressed, right? So that is the reframing that I want us to think about and bring into our lives and businesses when we look at how we can tackle the disputes effectively. Now, if we have come to a consensus that yes, disputes are a part of life, and in fact, presence of disputes is a sign of a growing economy, a thriving economy, the next question is, okay, now what do I do about the different varieties of disputes that I come to be bogged down by? And this is where what I was talking about, right? Today, the biggest roadblock for India's growth, and this is not something that I'm talking about. Recently, you may have heard this viral clip by one of the members in the Economic Advisory Council to the Prime Minister's office, Mr. Sanyal, making this statement that one of the biggest roadblocks today to India's thriving economy is the state of its judiciary, right? Judiciary is one of the three pillars of our democracy. The other two are executive and the legislature. Judiciary is expected to, at a very high level, keep a check on the government, keep a check on the parliament to ensure that the laws that the parliament is framing is as per the constitutional framework, so on and so forth. The way it keeps a check on the executive is by looking at whether, the orders, the rules that the executive is following is again in the interest of citizens, is adhering to the fundamental rights and duties framework that the constitution has laid down. At a more relatable level, judiciary's role is to help us resolve everyday conflicts. Only the Supreme Court and the High Court are tasked with these slightly higher order things, like ensuring that the legislature and executive are following the constitutional framework. But if you look at district judiciary, that is the first entry level access to courts, your local city civil court, or maybe your family court, the consumer courts. This tier of judiciary, we can, for ease of reference, call them the district judiciary layer, is what you will access as an ordinary citizen or as a business person. It is very rare that you will go to the High Court and Supreme Court level. And this tier, the district judiciary level, is what is tasked with dealing with our day-to-day contractual problems. So if you're a tenant and your landlord has not returned the deposit at the time of your vacating the premises, you go to your local court to seek justice. You file a police complaint, and then maybe you file a civil suit in your local court. How long does something like that today take, right? If any of you have had the misfortune of going through that process, you will have experienced what is normally spoken about when it comes to our judiciary today, that the process itself becomes a punishment, irrespective of whether you are a complaint initiator, which is a claimant, or you're at the other end of the stick as a respondent. Or when it comes to criminal justice system, if you have filed a criminal complaint and you are pursuing a case, The process itself today is so burdensome and filled with convoluted, complicated steps that the end goal that you're pursuing, that of justice, it not only remains elusive, but it also brings in a sense of disillusionment, right? You at the midway through, I'm sure any of you who have experienced the justice system have some very hard hitting questions like, is this even worth my time? Should I be devoting these many days, months, and years of my life towards pursuing this case? So that is the kind of feeling of helplessness that today our justice system leaves us with. In a tenancy dispute that I was talking about, typically it takes 3 to 4 years just to get the first instance order, right? From your district court, any order may be in your favor or against you, it takes around 3 to 4 years. And then inevitably, especially if the other side has deeper pockets, it has the willingness and ability to pay, that is, the cases, the order is appealed against, and you have to go to the appellate court. And in all today, even the simplest of cases take anywhere between 6 to 10 years to get resolved and see some level of finality. The question that all of us as ordinary citizens are faced with is this even worth my time? And most often the answer is no. So we do not pursue a lot of disputes that otherwise would have been in our favor, where we see that we have been wrong. We know that if there was a credible avenue for me to get redressal, then I would be entitled for some sort of compensation. I would be entitled to some sort of form of reversal of the situation, right? But oftentimes, as businesses, as individuals, we analyze the costs and risks involved, and what do we choose to do? We write it off, right? We write off the payments that are due to us. We swallow the bitter pill and move on with our lives because that seems like an easier choice today. That is the unfortunate reality that continues to plague us, and the numbers tell us that story very, very vividly. India's rank today, as you can see on the slide, is 163rd when it comes to enforcement of contracts. Now, at an individual level, of course, we are suffering, but if you just extrapolate this situation at the societal level, what we are truly getting affected by is the lack of rules based order in society. What does that mean? If you and I enter into a contract, I agree to do something, you in return agree to undertake some responsibility, and if either one of us breach that contract, we should have some effective remedy that we can avail. Now, given the situation, maybe one of us decides to write off. It's not worth person going after you because the court system is the way it is. Now convert that into 100x, 1000x, at population scale. If anyone today breaches contract, there are no real repercussions. So rule based society, which is the bedrock of any civilized society, where when one undertakes to do something, they do it on their own, and if they don't, there are real repercussions. And that fear is what makes people actually follow the commitments that they make, the commitments that they make in personal life, the commitments that they make in professional life or in businesses, right? And when this rule based society breaks down, there is chaos all around. Nobody is answerable to anybody or any institution. And we see that slowly happening in our society over the last few decades, right? When the courts have come to be overburdened, more than 5 crore disputes pending. And today, if somebody breaches and says, and the other side says, I'll take you to court, what do you say? Okay, I'll see you in court. No big deal, because it is going to take a few years and a few lakhs rupees in any case. So, no, I'm not really concerned, or I'm not really afraid of the repercussions. So, that is the situation. That is the reality today. And in terms of economy, MSMEs, these are the hardest hit, small and medium scale enterprises. These are small businesses, day-to-day living, right? Only if the payments hit their bank can they survive for the next month. Nearly 7.34 lakh crore of payments are pending. They are locked. These are all stuck in disputes. So can you imagine the extent to which the economy has come to be stagnated? Because again, there is no repercussion for not following what you promised. Now, it's not that there are no alternatives to the judiciary, right? Judiciary, we understand now that, it is almost like a bottleneck towards resolution. More than 5 crore cases pending. And again, the cost, which I mentioned in the line, which I highlighted in the last slide, nearly 30% of the dispute value. So for instance, if you are owed 1 lakh rupees, you're spending nearly 30,000 rupees in just recovery. So it does not really make economic sense. So that is the status of the judiciary today. But there have been alternatives, and these alternatives have been in existence for several decades now. You may have heard of arbitration, you may have heard of mediation. Both of them today are governed by parent legislations. There is Arbitration and Conciliation Act that was promulgated in 1996 and has undergone a few recent amendments. Then we now have a Mediation Act as well, which was adopted in 2023. What does arbitration mean? Arbitration, to put it simply, is like a private court. Two parties agree to resolve their disputes confidentially by appointing a neutral to decide their case for them. So the neutral arbitrator decides, similar to what a district judge would decide if you went to a court. And this has been in existence for a few decades, but the way it has worked, especially in India, is that it has become a rich person's game. So only large businesses or contracts of very high value end up having arbitration clause. Now, in any contract, there is something called a dispute resolution clause. And in this dispute resolution clause, the parties have the opportunity to decide how their disputes will be resolved when that situation arises. So, this is your dispute avoidance mitigation strategy, right? Every dispute goes through multiple layers. There is avoidance, there is mitigation, and then comes resolution. And for each of these, as an individual as well as a business owner, you need to have your own opinion and you need to also have your own strategy. In dispute resolution clause, you have that opportunity to decide how you want to address any conflict that may arise between parties to that contract. Now, arbitration, as I said, is something that is provided for in mostly high value disputes. And this has come to be the case because the way the arbitrators have come to be appointed, we are looking at mostly a retired high court judge or a retired Supreme Court judge who post their retirement have come to command very high fee. Per sitting fee that they charge in an arbitration is extremely high. So ordinary citizens like you and me are mostly not in a position to pay that kind of fees, which has meant that for small value disputes, the default has always been, go to your court. And similarly with mediation, not similarly, but even with mediation, it hasn't taken off as it should have, because mediation, to my mind, is the best mechanism to resolve any kind of dispute, especially such disputes where you want to preserve relationship with the other side. Mediation is a mechanism where you bring in a neutral facilitator to mediate a settlement between the two disputing parties. So here there is no win or lose situation. It is mostly win-win situation that the facilitator is aiming for. Because oftentimes in any dispute scenario, it is likely that there is some scope for give and take. There is no clear, black and white in terms of who is right, who is wrong. Not everything is like a murder situation. And even in a crime as grave as murder, the court and the judge always look at what are called mitigating factors. What was the situation in which that murder, something as heinous a crime as that, was committed? So even there, not everything is black and white. But by default, then in a contractual scenario, it is likely that there are some situations that may yield towards settlement rather than having a clear cut award which says no, party A is wrong and party B is right. So the entirety of the amount needs to be paid from party A to party B. That is what happens in arbitration and that is what happens in court. Court is an adversarial system. But in mediation, there is scope for some level of give and take, which ensures at the end of it that the relationships are not soured. So if you think about it practically, most of our disputes ought to be resolved through mediation because it just makes sense. However, today, mediation is not a preferred avenue, and there are multiple reasons for that, including lack of trained mediators that are immediately available and discoverable to parties. If today you have a dispute and you want to explore mediation, it is not a very easy problem to solve in terms of discovering that right mediator. In fact, within courts, there are court annexed mediation cells. If a judge thinks that your dispute is likely to be better resolved through mediation, they can send your dispute to the mediation cell. But even there, unfortunately, the court annexed mediation centers have not really fared well in giving quality assistance to parties in ensuring that the facilitation of mediation itself is done in a way that there is higher chance of settlement. Recently, in fact, the Ministry of Law and Justice released data regarding commercial mediation centers. So under the commercial disputes, under the commercial cases, I forget the legislation name, but where commercial courts have been established specifically to deal with such matters, mediation is compulsory component before you enter the court system. And there, unfortunately, less than 2% of the cases have been settled through mediation. So there is a lot that needs to be done in terms of awareness building, capacity building, and finally ensuring quality settlement. But the biggest hurdle has been that all of these have been offered as a brick and mortar solution, right? You still need to go to a center, you need to file your physical copy of the file, and then you have to wait for your hearings. All the parties need to come together in a particular setup, and only then can the case proceed. So everything that today seems unnecessary given the digital age that we are in. Today we are all connected via Zoom, and I don't think there has been any issue in being able to effectively communicate, and we are doing this at the comforts of home. Imagine I were a mediator or I am an arbitrator sitting in my home office and parties are presenting to me their case. That would be an ideal situation, right? This can happen any day of the week, any time of the day, and the cases will move on. So that is the new reality that we are working towards. So let me now introduce the core topic today that I want to spend some time on, which is digital dispute resolution. And the question that is very obvious, especially for those of us in metropolitan cities used to ordering from Blinkit, Zepto, and what have you. Everything is in the matter of minutes. But why should justice take multiple years and uncertain costs? Right? And the answer to that is online dispute resolution. Now, ODR or online dispute resolution became one of the key drivers of access to justice when we were in COVID era, right? 2019, 2020, when all the courts were shut. So many cases getting piled up, people suffering because there is no end in sight. That is when the government of India and Niti Aayog very seriously looked at what the alternatives can be. And Niti Aayog constituted an expert committee under the chairpersonship of Justice Sikri. He is a retired Supreme Court judge. I had the opportunity to be part of that committee, and together we were able to draft one of the most comprehensive reports on online dispute resolution anywhere in the world. We sought inputs from experts across the world. We conducted multiple consultations with ministries, departments across the country, with private institutions here in India, legal experts of all kinds. And all those inputs have been consolidated to formulate the Niti Aayog report, and it's called Mainstreaming Online Dispute Resolution. So far, both arbitration and mediation were considered to be alternatives, but now the idea is those alternatives should become the mainstream, and they should become mainstream by the aid and integration of technology very, very deeply. We are in the era of AI, so nothing which is in the form of a service can remain untouched by technology. So, how do we mainstream alternative avenues of dispute resolution and ensure that court becomes the last avenue for resolution of any kind of dispute, because that is in fact what those courts were set up for. The courts, the way they were established originally, were never meant to handle the kind of day-to-day disputes that today are entering the system in thousands and lakhs. They were meant to be an exception. Only when people couldn't resolve the dispute amongst themselves should it enter the court system. That was the original idea. And that is what we want to go back to. Enable by creating a solid infrastructure, empower the parties to resolve disputes, to mitigate disputes, and if possible, to even avoid disputes. And if all of this fails, only then you go to court, right? So that is the fundamental idea that we are working towards. And how do we do that? Right? There are three layers to any kind of resolution, and this is something that you all may have experienced in any dispute scenario as well, right? There is first layer of negotiation, where you directly go to the other side and try to figure it out. This is when the relationship is still at a level where communication is directly possible. Even here, it is necessary that some level of technology layer is introduced, because it makes it more structured, as opposed to you having a WhatsApp communication or you having direct communication across the table, where the bare bones of it are not recorded for future purposes. It is better that through institutional support, even that negotiation becomes a very structured communication. The second prong of the dispute resolution is mediation, which we have already understood as a theoretical concept. Then comes arbitration. Arbitration is the most escalated form of dispute resolution outside of court, because here you get a binding decision. Both in mediation and arbitration, you should be aware that the outcome of it, which is the settlement in the case of mediation, and an award in the case of arbitration, are something that you are bound by the same way you are bound by an order of the district court. Just that these are meant to be seamless, less cost intensive, and more efficient. That is the purpose of these mechanisms being present outside of court with legislative backing. Through technology, the idea is that all those requirements of these alternatives are actually met. And that is where the role of an institution becomes critical. Now, we know that yes, these alternatives exist. Okay, arbitration exists, mediation exists. Okay, I can include arbitration and mediation in my dispute resolution clause in the contract that we enter into. Now, how do you go about it when you're actually in a dispute scenario? Right? In a dispute resolution clause, you have the option of going with either an institution or ad hoc. What does that mean? In a dispute, in the way the dispute resolution clause is worded, you can say any dispute that arises out of this contract will be resolved through mediation followed by arbitration. You can leave it simply or to this extent. What that means is, when the dispute arises, the parties have to, in that dispute situation, identify, okay, mediation. Who can I appoint as a mediator? Who can I appoint as an arbitrator? What will be the process that will be followed? What is the timeline that will be followed? What are the costs that I will incur as a party? So all those questions will be left open-ended if your dispute resolution clause is bare bones, where you just identify the mechanism and leave it at that. On the other hand, if in your dispute resolution clause, you state that if any dispute arises under this contract, the parties will attempt to resolve through negotiation, followed by mediation, which will be a time-bound exercise of 30 days, followed by arbitration if mediation is not successful. And both mediation and arbitration will be administered by an ODR institution like court, from court. So obviously I will talk about court, right? By Center for Online Resolution of Disputes. What this means is that when a dispute arises, you will be bound by court's rules of mediation and arbitration. Now, these institutional rules define frameworks in terms of who will be appointed as your dispute resolution professional. What is the timeline that will be followed? And you will be supported by case managerial assistance. The way it works at court is every case gets a case manager who will coordinate between you and the neutral. That may be a mediator or an arbitrator. So it is a lot more of a service that we provide to the parties than what you may have experienced in courts, where you are mostly left to fend for yourself, or you're heavily dependent on the lawyer to give you all the information. Because rules itself you don't, laws itself you don't really understand, and you don't really understand what is happening in court. But with an ODR institution like CORD, there is complete transparency. You can log on to the platform that CORD has. You can track when the case has been filed, how many days left for the next stage, what is the profile of the arbitrator appointed for your case, how can you connect with the case managers if you have any doubt. So every step of the way, it becomes a seamless process, all meant, or at least everything has been designed to ensure that your dispute resolution experience is something that is far more seamless, that does not become burdensome, that does not become like a fear mongering exercise for you. So that is the approach that at least CORD takes as an institution, and any institution for that matter will give you some level of comfort in these aspects, that there will be rules, that there will be vetted panel of neutrals, which means you are not in a dispute situation wondering who should be the arbitrator or mediator. The institution itself will have a vetted panel of neutrals. For instance, we train our arbitrators and mediators. We identify who is the right fit for the kind of dispute that comes to us. If it is a tenancy dispute, if it is, for instance, an RWA dispute, we regularly deal with neighborhood disputes. And these are small value disputes that for which you don't really want to go to a court, right? For instance, somebody has not paid their maintenance dues to the RWA, or there is some neighborhood conflict that needs to get resolved. We come in and appoint a mediator there. So these day-to-day issues that keep nagging your mind, those are also the right cases for ODR. And we curate our panel of neutrals to be very, very broad. We also have extremely complicated cases. A shareholders agreement dispute today that is running on our platform is worth 10 crores. So we have a partner from a very reputed law firm appointed as an arbitrator there. On the other hand, we also have cases, as I said, neighborhood conflicts, tenancy disputes, for which we have someone who is less experienced but has expertise in that particular area. So with an institution, you also get to have a judge, a neutral, who is more suited for your case, unlike maybe what happens in court, right? Broadly, the judges are trained in judicial academy, all of that is there, they come with their reputation, training, all of that, but you don't really know if they are the right judge for your case. Do they really understand the complexity or the various angles involved with your case? And you don't really have a choice, you can't keep changing judges, right? While our rules also provide you with the ability to challenge the appointment. You can ask for replacement if the neutral is conflicted or for whatever reason is not identified as suitable by the parties. Then the most important component of an ODR institution is the technology platform itself. Through the technology platform, you're able to exchange documents securely, confidentially. Confidentiality is key principle of both mediation and arbitration. When you go to a court, for instance, everything is a matter of public record. I can sit and Google your name, and if you have been embroiled in any case, it will show up, right? But with mediation and arbitration outside of court, the security, you can be secure that it won't become a matter of public knowledge, and that is the creature of arbitration and mediation itself, that the proceedings will be confidential. And our platform, the technology platform that we have at CORD, is designed to ensure that that confidentiality is maintained. You can exchange documents in a manner that it will immediately send alert to the other party that document has been uploaded. Again, unlike what happens in court, something has been filed and you have to wait for a month more to figure out, okay, what has happened in the previous hearing. Then we also have the ability to send multimodal communication dispatches. What does that mean? I can send a notice to WhatsApp, through email, through any sort of messaging platform, and all of that gets tracked. If you open the WhatsApp message that CORD sends, I will get a notification. So the notice period becomes a lot more efficient through CORD than otherwise what we see in the court system. These are broadly the four important components of an ODR institution, of any ODR ADR institution, and the same holds true for CORD as well. And with CORD, as the last line indicates, our average dispute resolution time for the last 82 days. In 82 days, we have gone from initiating the dispute until final resolution. And unlike what we saw with courts, where it takes 31% of the dispute value, I told you out of 1 lakh, nearly 30,000 you're maybe spending in legal fees and in other kinds of costs. But with us, it is mostly 2% of the claim value that you end up spending on our platform. The next big question obviously will be whether ODR is legally binding. Let me take two quick case laws. One case law is something that CORD itself has in its favor. CORD as an institution facilitated arbitration in a tenancy dispute. The other side went and appealed against, challenged the award given by CORD arbitrator here in Bangalore Commercial Court. And the Commercial Court went through the process that CORD adopted in appointing the arbitrator, the process followed for the entire dispute resolution life cycle, and upheld CORD arbitration award. So today, if you have a CORD facilitated arbitration or mediation, it is as good as you having a district court judgment that you can go and immediately execute. Similarly, in like late last year, December 2025, Bombay High Court very categorically stated that, but in Amit Chaurasia case, the Bombay High Court upheld again an ODR institution's validity, the platform rules, and also the process of resolving dispute through an online institution, end-to-end online institution. The Bombay High Court has upheld it. In terms of end-to-end process, this is what broadly we go through. Cases ingested directly onto our platform. We can ingest one case at a time, or we can also take in hundreds of cases at a time. This is typically the scenario when it comes to, say, a banking sector dispute where hundreds of loan default cases are sent our way, and we are able to, at the click of a button, onboard all those cases. And we can also have API integrations with in-house counsel teams so that the case intake, which is equivalent to filing stage in the court, becomes as seamless as possible. Then, as I said, we have multi-channel outreach mechanism, that is the notifications that are sent. Then arbitrator and mediator is appointed based on the category of dispute and strictly in adherence to the processes that have been identified under the Arbitration Act and the Mediation Act. Then we have, in terms of the values that we unlock, timely communication, case management, transparency, comprehensive support, right? All these are what determine how your experience is. Some of them are tangibles, right? Whether you're getting the data on time, whether the neutral is taking you through the process in a proper manner. But the other is you being aware of what is happening, you being aware of what the next step is, you having that ability to reach out to someone when you're in doubt. All of that is the institutional support that you are guaranteed when you go through an ODR institution like CORD. And at the end of it, we also assist the parties with enforcement pack. So in case the award states that you're entitled to so and so amount, what are the next steps, right? How do you actually get that amount in your bank? That is the closure that we all want, right? So the enforcement pack, including Section 63 certification, is something that we give to the parties at the end of the entire dispute life cycle. This is a quick plug-in. We are, as I said, in any contract, you have to add a dispute resolution clause. That is the only way in which CORD will get the authority to administer your disputes when you're stuck in a dispute scenario. It is very difficult for the parties to agree to anything when there is already conflict between them, right? Which is the reason why you have that opportunity at the time of drafting of contract to identify what institution you want in the dispute stage, and what are the various components of it. Do you want only arbitration? Do you want negotiation, mediation, arbitration, or only mediation and arbitration? So you can do a combination of all three and accordingly draft. And you have to draft it very carefully to ensure that when there is conflict, you're not stuck.
Thank you, ma'am. Thank you so much